Hi everyone, this is chapter 17, the final chapter. Chapter 17 is combined with chapter 16, but the lecture is separate. So let's look at the myths and facts on page 515 of your textbook. You should have your PowerPoint open, your textbook in front of you. You should have already read chapter 17. So page 515, and this has to do with the myth and facts about criminal court proceedings. Myth: if a person is arrested or given a citation, the case will automatically be prosecuted, and he or she must stand trial for all the offenses alleged by the police. Not true. Fact: the decision whether or not to prosecute, including what charges should be filed, rests on the discretion of the prosecutor or the grand jury. Myth: the fact that a person was acquitted clearly establishes that the police made an illegal arrest. No. Fact: the standard for conviction is much higher. It's like 95% certainty, beyond a reasonable doubt, right? And the percentage to arrest someone is only 51% minimum for probable cause for an arrest. So you're looking at 51% compared to 95%. So the standard for conviction is much higher than the standard for arrest. The jury may decide that the prosecution has not proven the guilt beyond a reasonable doubt, even though the police had ample facts to establish probable cause for the arrest. I'm sure we've all seen shows where the jury acquitted someone and we're just absolutely baffled why they would. So you never know what a jury's going to decide. Myth: criminal cases sometimes take a long time to get to trial because the prosecution has to finish its investigation and request repeated continuances. That's not how it goes. Actually, fact: absent extraordinary circumstances, long delays in proceeding to trial violates the defendant's right to a speedy trial. So that doesn't happen on the prosecution's end. Many delays are due to the defense wanting to delay it. There may be various strategic reasons for that. Myth: witnesses who testified at the preliminary hearing are required to keep the prosecutor informed if there are changes in their addresses or phone numbers. Fact: witnesses have no duty to notify police or prosecutors of their change of address or phone number. It is usually the duty of the police to keep track of how to locate the witnesses when they are needed in court. That can be challenging. Look at slide 5 of your PowerPoint. Reviewing the facts of a case. For the prosecutor, they want to look at what was the probable cause for arrest. Again, the 51% minimum that a suspect committed the crime. Was the correct criminal charge used? Were there any potential violations of the suspect's constitutional rights? What is the possibility of conviction versus acquittal? Can each element of the crime be established beyond a reasonable doubt with 95% certainty that the defendant's guilty? How credible are the witnesses and evidence? On page 517 of your textbook, take a look at the chart 17-1, and then let's look at the second paragraph. Credibility of the witnesses is critical. The fact that the investigating officer believes the witness is not enough. The jury must also believe the witness. Objectively advising the prosecutor of factors that enhance or detract the credibility of witnesses is important. Hiding weaknesses of the witnesses from the prosecutor is not going to help the case. Defense attorneys specialize in demolishing the credibility of weak witnesses. So true. There's special instructions that New Jersey gives their jury, and that's at the bottom of page 517 and the top of page 518, which I'm not going to read to you, but it is pretty interesting if you want to read that. Slide 6, working with the prosecution. They preparation of the physical evidence. There needs to be established a strong chain of custody, which we talked about earlier, which is frequently attacked by the defense. A break in the chain can make the evidence inadmissible. All evidence must be marked and signed for. The significance of each piece of evidence and knowing the significance is important. And understanding the strengths and weaknesses of the evidence is important. Let's look at the bottom of page 519 of your textbook. Last paragraph. In order to introduce physical evidence at trial, the prosecutor must know where the item has been, who had access to it, anything that has been done with it since it came into police custody. And this is called chain of custody, prior to admitting that item of evidence. Top of page 520, actually the second paragraph of page 520. How much time do we have? Okay. If the police tell the prosecutor about the positive tests conducted at the forensics lab, but do not mention any negative results, that prosecutor may falsely believe that the case is very strong. You actually could be fired for that too. It's very unethical. Facts not known to the prosecutor may also give the defense an added edge during cross-exam. In fact, the prosecutor's lack of knowledge may even result in dismissal of the case if the defense can convince the judge that it was denied its constitutional right to discovery. So in other words, all forensic personnel are trained to provide all results. Positive, negative, whatever it is, it should all go to the prosecution, and that's discoverable. The defense will get that. Defense attorneys routinely file motions to suppress evidence based on illegal search and seizure. For this reason, the prosecutor needs to know all the facts and how each item was obtained. The same is true for confessions. Okay, look at slide 8, database on sample evidence. Each piece deserves a separate entry. Not just deserves, that's crucial. Actually, every piece of evidence should be packaged separately. There are departments that don't do that. I don't think, well, maybe there's not anymore, but I hope not, because that's not good. So each piece of evidence needs to be packaged separately. It needs a separate entry giving a description of the item, where it was obtained, facts that justified its seizure, chain of custody, tests performed. Each piece of physical evidence needs a witness to guide it to admission. Usually it's a police officer or forensic technician that will take the stand and give testimony. Questions are asked as to how they obtained the evidence and what they did with it. And all that should be in the report too. Slide 9, witnesses. A complete list of witnesses should be prepared from both the prosecution and the defense. Not everyone on the list may be called though, but evidence each party on the list would give needs to be known. Page 522. Let's look at a little bit more about witnesses. It is common for prosecutors to ask the police for a list of witnesses. If time permits, a meeting may be set up to discuss the credibility of the witnesses and which witnesses should be subpoenaed. A subpoena in some states is also called an order to appear. It's an official document that indicates the date, time, and location where the person should appear, as well as which attorney issued the subpoena. A subpoena, duces tecum, called an order to produce documents in some states, is used to order a person to bring documents and other tangible items to court. Delivering the subpoena to a witness is called serving a subpoena, and in most states, anyone aged 18 or older who's not a party in the case can serve a subpoena. Skip down to the next paragraph. A person who has been subpoenaed and fails to appear can be held in contempt of court. This can result in a warning, a fine, or jail sentence. It is also possible to jail a person who is crucial to the case as a material witness, and that would prevent him or her from fleeing the jurisdiction or hiding to avoid testimony. If possible, each witness should be deposed, or deposition should be given, a written or oral statement regarding what they will say in court. Slide 10. Presence of witnesses may be compelled by a subpoena. It may be necessary to impeach any witness or to rehabilitate an impeached witness already. We talked about that earlier in the semester. Look for obvious problems: arrests, eyesight, motive to lie, or to be truthful. Bottom of page 523. The prosecution cannot call the defendant to the witness stand in a criminal case. Boy, I bet they wish they could. It may be necessary, however, to call witnesses who are sympathetic to the defendant because they witnessed the crime or have other relevant information. When this is done, the prosecutor will ask the judge to declare the person a hostile witness. The same procedure is used, page 524, if a witness who is called by one side unexpectedly gives testimony that is adverse to the side that called him or her. Once the judge designates the person a hostile witness, the attorney who called the witness proceeds like he or she would while cross-examining a witness for the opposing side. Leading questions normally not allowed during direct examination can be asked. Slide 11. Okay. Database on witnesses. A database on each witness should be constructed. Name and alias of witnesses, current address, general content of their testimony, their strengths and their weaknesses.